Hey everybody, welcome back to the Shanty. It's only been a couple of days. We're going to talk about the FTC's final rule with respect to non-compete agreements and their attempt to void non-competes nationwide. Now, I wasn't going to do this initially, and I wasn't going to do it for a couple of reasons. Number one, I just did one of these on Title VII in the Supreme Court. If you haven't seen it, go look at it. I think it's pretty good, and it'll be of interest to all of you. Number two, we just did an eAlert on this yesterday, as I'm recording this, actually this morning. And the team that did that wasn't me. The team that did that did a brilliant job on it, told you everything you needed to know. And number three, the rules that the FTC issued are 570 pages long, and I haven't had a chance to read them. But my phone rang off the hook this afternoon, and a bunch of you sent emails saying, what does this mean? And what do we do? And something new happened. Well, what new happened that caused me to do this? Because my love for you isn't the reason. Well, it's not the only reason, it's part of the reason. But what happened? What happened was, as we told you in the eAlert yesterday, we felt it was highly likely. As a matter of fact, the U.S. Chamber of Commerce said they were going to sue to stop the implementation of this rule. Well, they were as good as their word because they sued on the 24th, yesterday when you're watching this, today when I'm making it. And clearly this was something they had planned well in advance. They got together with a bunch of business groups, and they filed a lawsuit in the Eastern District of Texas. Why the Eastern District of Texas, you say? Because that seems to be the court everybody files these lawsuits in when they want to get something the federal government does overturned lately. That's where the last set of DOL regulations were enjoined nationally. I think even the vaccine mandate might have been filed on there, but I'm not sure. But that seems to be the court. I say it was planned because the complaint is 50 pages long, and you don't write a 50-page complaint overnight. So let's talk about the rule and what the lawsuit means. Let me start with just a little reiteration of the rule from our eAlert. And I told you I haven't read 570 pages of regs. I haven't, but I have read our eAlert, and I have read the FTC's announcements on this and the Q&A. So I've got a basic understanding of what the rule's doing. Three primary things. Number one, it's going to ban all non-competes that go into effect after the effective date of the rule. The effective date of the rule is 120 days after it's published in the Federal Register. As far as I know, as of tonight, it has not been published. Probably be published on Friday if it's going to be published. That would be my guess. So we're looking at about 122, 123 days. So it bans all non-competes after the effective date, and that's for workers, not just employees. So it's a broader concept than just employees. Number two, it prohibits the enforcement of any existing non-compete that's currently in place. And the Chamber took exception to this. It's part of their lawsuit, and I'll explain that in a minute, except for senior executives. What's a senior executive? It's somebody in a policy-making decision who makes at least $151,000 and change a year. And number three, it requires all employers who have covenants not to compete with their employees to actually write the employee and tell them you're not going to enforce their covenant not to compete, and it's against the law to enforce their covenant not to compete. And you have to do that either by email, mail, or a text to the worker, and it has to identify the worker. So no, mass emailing. It's going to have to be individual emails to the people that have the contracts. The rule doesn't apply to confidentiality or no solicitation agreements, but be careful with those no solicitation agreements, because if they're too broad and in effect non-compete agreements, the FTC has said we're going to enforce those like non-compete agreements. And number two, it doesn't apply if you are an owner of a business and buying or selling a business. So if you're selling your business and as part of the sale, you enter into a non-compete, that's still going to be valid. All right. So that's the rule. What's the lawsuit? Chamber filed a 50-page complaint, as I already told you, in the Eastern District of Texas. It has 6 counts alleging various violations of certain parts of the FTC Act and the Administrative Procedure Act and even the Constitution. Count number 1, the Chamber claims that the FTC lacks substantive rulemaking authority. That is, they do not have the authority under the FTC Act to make a substantive rule like this. They only have the authority historically to make internal rules regarding investigations. Then they say if there's any doubt about the rule or their authority, the major question doctrine governs. The major question doctrine has come up a lot lately. It's a legal doctrine that we're not going to get into, but suffice it to say, the Chamber thinks the major question doctrine would govern, and that the Commission lacks the power to issue these substantive competition rules. Count 2 is an unlawful interpretation of, quote, unfair methods of competition. The Commission says the non-compete rule violates the law because the Commission's attempt to designate all non-competes across the board as unfair methods of competition is contrary to Section 5 of the FTC Act and exceeds the Commission's authority under that provision. Count 3 is a constitutional question, is an unconstitutional delegation of authority to the FTC. In this case, the Chamber says, to the extent Section 5 of the FTC Act could be interpreted broadly enough to give them the power to adopt this rule, that provision violates the non-delegation doctrine under the law. The non-delegation doctrine holds that a statutory delegation of authority to an executive agency, remember the FTC is an executive agency, it's not part of the legislature, it's an executive agency, is constitutional only when Congress lays down by legislative act an intelligible principle to cabin the agency's discretion. Here they're saying that you did this because the president issued an executive order, not because Congress gave you the authority to regulate in this area. In count 4, the Commission claims that the rules are unlawful because they're retroactive. Remember, I told you that the rule would say that any agreement that you've entered into already would be voided and would not be enforceable. Well, that's retroactive effect. When you entered into that non-compete 5 years ago or 2 months ago, it was legal for you to do that, at least here in Michigan, as long as the thing was reasonable and followed all the rules. But this would make it illegal. That's a retroactive application of the rule, and the Chamber claims that the Commission doesn't have the authority to do that. In count 5, they say that the Commission failed to engage in reasoned decision-making. And here they point to the Administrative Procedure Act. And what they say here is, I'm going to read to you, quote, a choice to fundamentally remake the American economy requires substantial factual support. But here the Commission has opted for an unprecedented and extreme policy without pointing to any economic evidence that supports that decision. The Commission, they say, ignored, if you will, the arguments for non-competes. And there's lots of history across lots of states that non-competes are legal and enforceable. There's only a few states where they're not. California's one. I think Oklahoma's another. So, according to the Chamber, you didn't engage in reasoned decision-making. And the final count is a failure to consider alternative proposals. And here the Chamber argues that the Commission failed to meaningfully engage with any of the number of alternatives that were presented by commentors in the comments, that a bunch of less extreme alternate proposals were proposed and that the Commission just ignored them. And here's what the Chamber says. The Commission confirmed that its ultimate goal was never to implement a final rule that balances the costs and benefits of a ban on non-compete agreements, but rather to achieve a politically predetermined objective, end quote. So what do we do now? That's the complaint. That's the rule. That's the complaint. What do we do now? First thing we do is take a deep breath, okay? even if this thing was going to go into effect without challenge, it doesn't go into effect for 120 days from the date it's published in the Federal Register. So we have time to get ready. Number two, it doesn't really require you to rewrite anything. Although one of the things we might want to consider if this rule does go into effect is if you have a non-compete coupled with an intellectual property agreement, coupled with a confidentiality agreement, remember those intellectual property agreements and those confidentiality agreements are still valid. We should discuss at some point, do we just say to people, hey, look, the non-compete part of that agreement is not enforceable, but everything else is? Or do we write a new agreement? Do we start over again? Those are something that you're going to have to talk to your labor lawyer about what the best way to go is. Okay? But it is likely that there will at least be some delay, and we're not going to have to make those decisions quickly or within 120 days. So what we really need to do is not panic, not change anything, and just wait. Now, the big question is, do you continue to enter into non-compete agreements in the interim period? And the answer to that question is, I don't know. That's something we're going to have to talk about. Should we consider maybe just non-solicits, just confidentiality agreements, or are you going to continue to have people sign non-compete agreements? And I think that, again, is going to depend on the facts of your particular circumstance. So you're going to want to call your labor lawyer and talk to us about that before you do it. So that's where we are today. In other words, deep breath, everything's cool. Nothing's decided yet. We got a long way to go before we get to a total nationwide ban on non-compete agreements. And I think, this is just my opinion and it's complete speculation, I don't think this rule is going to go into effect. I think it's going to get enjoined by the court and ultimately it will be overturned. So now we wait and see. For those of you that are wondering, because you notice that our eAlert did also include the DOL's new rules on overtime. Yes, I'll do something on those, but give me a minute. Those regulations are short. They're only 325 pages. And for the last couple of days, I've been reading the regulations, another 500 or so pages on the Pregnant Workers Fairness Act, and I'll get something out on that too. Although we're going to discuss a lot of these issues at the seminar on May 1st. So if you're not signed up, sign up, and we'll see you there. Thanks a lot. See you next time.